There's been a recent change a couple of years ago that in the US it has become more important than ever to be the first to file, whereas we used to be an actual first to invent. We were in the minority in the world in that, whereas most other countries you just had to file first, and whoever filed first won the race to the patent office. So now that we have that, we suggest to every client to file first and file often. There's something called a provisional patent application, which is lower cost. Again, it's almost like an intent to use application for trademarks, whereas you're saving a date by filing a provisional application, and you don't have to have the full patent drafted out, although it does need to fully lay out what your invention is, how it's going to operate. And it's a lower fee to file, but you do need to, within 12 months of that, file a non-provisional. Otherwise, the provisional will just die and nothing ever happens with it. It can't be converted. You need to, within 12 months, file a non-provisional based off of that, claiming priority in order to capture the earlier provisional date. Also very important to know is that if you come up with a new suture, a new catheter, and you use it, and you're using it for 2-3 years, you lose the right to file for a patent. You must file within 12 months of making it publicly available, using it in public, selling it. There's a lot of things that trigger this 12-month bar date. So it's very important that as soon as you come up with an invention, you speak to a patent attorney to see if there is something there, and also file a patent as early as possible, because you can, even if you're only using it in your own office and no one else knows about it, maybe even the patient can't see it for some reason, that use alone will trigger that date, and you can potentially bar yourself from obtaining a patent.